time for the inquiry to resume. Can I just check that everybody can hear me? And can I just get a thumbs up if make sure the live stream's working? Thank you very much. Just the usual reminder to make sure that all phones and laptops are switched off and doorbells aren't ringing and things like that. Just before I ask Mr. Cambourne to take Mr. Lee through cross-examination, there's just a few procedural things I wanted to raise. I can confirm that we've had the cost response from the applicant, so thank you for that, and that will be published on the website in due course. Yesterday, Mr. Clegg mentioned the note that had been provided for Mr. Essential's evidence, and just to confirm that, having considered what the applicant said about that, and having discussed that with Mr. Clegg, we've decided that we'll accept that. So again, that will be published on the website. Also yesterday, there was a discussion about the land value uplift documents, and I think there was a request as to whether or not the WSP with all its appendices could be effectively trimmed down. Is there any progress on that?
Short answer, no, sir. My suggestion is that we do that when Mr. Lee's completed his evidence, because I'm going to ask him about some points in that document. I think we can cut it down, but reluctant to decide what we can cut out until we've been through the questions. Because it may be, if we cut something out, it's fairness on both sides, because Mr. Lee I might ask him about some point that I've put in that I would like to be in, and he might want to go to some other part of the document which has been taken out. But I think we will be able to take out quite a lot.
Okay.
On the other hand, they are electronic, and we're not asking anybody to read all 500 pages. I know it's not good practice, but we'll take it out, but if it's helpful to you, sir, we'll have a paring down.
I'll just ask Mr. Barker if you've got any comments on.
Nothing to add.
And are you happy to proceed on
yes.
that basis?
Yes.
Oh, okay. Well, I think on that basis, yeah, we'll leave it as is. Also, yesterday, I think we got to a position where we'd asked for, in terms of the highway boundary plan. I think my understanding was that we'd effectively asked just for a simple plan showing each party's views of the boundary where it differs. I think that's what we'd asked for.
Yeah, I think it's been something of a moving feast in terms of, I know it's clear what you asked for. I think when the answer came back, there was these discrepancies between what's shown on the boundary map and the actual extent of the boundary. So I think we haven't produced anything beyond what was produced yesterday by this morning.
Okay.
I think we would still benefit from just absolute clarity as to what you would find most helpful in terms of, if we're going to go away and produce further documents, what that would be.
Well, in that case, just to be clear, I think obviously we got the sections from the applicant which sort of indicated where the land search boundary sort of matched up with the boundary on the Appendix F plan, but it also illustrated with a purple line where there was a difference, where I think the CPF were using the county council's, I'll call it the green coloured plan, and that's where there was a difference. I think what we're just after is just something, say, a plan showing the applicant says the highway boundary is here, CPPF says the highway boundary is here, just so it's really clear, so we can just see the two different positions and just understand that.
Yeah.
I mean, again, I note the caveats that are provided on the applicant's drawing, and that you know, in terms of things that could come up on a land search, in terms of where an actual land parcel boundary is, and the interpretation of what where the adopted highway is. So I think we understand the caveats that come with that. It's just to understand what the difference is between the parties and where it is. Because at the moment there's a number of different drawings that we need to look at to deduce that. Does that sound okay?
I think particularly bearing in mind that one of the arguments is that the alternative scheme is within the highway. What we need to understand is what each party's understanding is of the highway.
Well, so our position is as shown on those sections. What we've done, so rather grandly, somebody much more competent than I am at these things, has done, is to draw the red vertical line on the land registry title boundary, and has then considered whether that is coincident with, as he puts it, with the green plan. That's the Highway Authority plan. Now that's as far as we go. Now CPPF, I think, say, well, you have to look on the ground to see where the boundary features are, and they rely on the presumption that the boundary extends beyond between the boundary features. Now that's not something that we have done. That's not something that we're planning to do.
Yeah, sorry to talk across you there.
Yeah.
We're not asking for an interpretation of that argument about the features, and I recall there was a discussion about, for example, the hedge outside the cemetery. On some sections it's outside the highway. I think what we want is the two-dimensional plan version of the section, just to show, so that so for example, the highway drawing with where there's a difference between what the CPPF are saying is a highway boundary, and you're saying actually no, the land registry show the line is here. So it's just basically a plan version of the section, because the section just shows us one point.
But those are the green plans, sir. Those are the local highway authority drawings, the green ones as you referred to them. That's what they are. We can't add to those.
But I think what we can do is CPPF have interpreted the topographical features, so the purple lines on the civilistics drawings will be different to the plans on, and that's where the discrepancy arises. So we can definitely produce a plan which compares, and I know because I saw it on one of the WS teams, I'm not sure what his name was yesterday, who took us through the plans. That's the exercise that he had undertaken, was to overlay the topographical survey of the highway over what the county council's plans were. So I am reasonably confident, based on what he told me, that he can produce the plan that you are looking for, which illustrates those two positions essentially.
So just so I'm clear, so, for example, if we go to that particular section where there's both a red line and a purple line, the applicant, you're saying that actually your red line is the same as the green shaded county council one, and so the purple line is the CPPF's interpretation of the highway based on the physical features, just so I'm clear on that. Is that correct?
Yes, essentially, I wouldn't use the same terminology, but when you say interpretation, the county council plyway hands are not definitive as to the highway boundary. So what we've done is say what we say the highway boundary is, according to all the legal presumptions that one would be required to apply when understanding what the highway is. But yes, essentially, the red line follows what you see on the non-definitive plan. We say that's not the highway boundary. You look at what the actual highway is, and that's the boundary feature. But yes.
So in that case, and again, I want to make sure I'm not getting myself muddled here. The applicant's saying that the Green County Council plan aligns with your land registry searches. So you have for that. So the difference is between the green line and your, I'll call it the purple line.
Yes.
Which is what I said earlier, sir.
Well, it's good that I get an understanding of these things.
Yes, absolutely.
So in that case, I think if you're able to provide that.
I don't know who is best placed to provide that. We have, yes. I mean, I think the The gentleman who took us...
Mr. Newman.
Mr. Newman, who took us through yesterday, I think had all the overlays on the plans that he had produced. So, I mean, I don't know whether he is best placed to do it.
I think now that we've established clearly what I think we want, which is just that very simple, the applicant's position is this, CPPF's position is this, so we can see where the difference lies. Could I ask both parties to see what they can...
We'll take that away.
We will obviously cooperate with, I don't know what Mr. Newman, I wasn't involved in that discussion, but our position is, and I'm repeating myself, highway boundary as shown on the Highway Authority plans, which are the green plans, and that is reflected by the vertical line. So I'm reluctant for us to start doing some other exercise, but if CPPF want to, and it helps you, sirs, we will volunteer somebody from WSP to put it on a drawing, but it will be the CPPF position,
yes.
not ours.
Yes, no, thank you. No, I'm clear now exactly where the different origins are from. So no, that's quite understood. And thanks you for explaining the position. But yes, it would just be helpful so I can see in two dimensions where the differences between the parties are. It doesn't need an additional commentary because I think both sides have made it very clear what their views are about that. So yeah, I think we're just after a plan.
Yeah, I do understand that, sir. I am conscious that I'm very keen to make sure you are very clear as to the CPPF position as to what would need to be determined to determine the highway. That it's not determined by the plan that the applicant is producing. That's not a determinative plan as to what is and isn't highway. And as long as you're very clear on that, then there's no further need for any further explanation. But
well, I think we heard something about that yesterday with Mr. Johnson, didn't we, in terms of highway?
I don't think there's ever been any written material about how one goes about determining the extent of the highway, the presumptions that one applies, the status of the County Council's plan, which is a non-definitive plan. They need to go out on site and actually look at the features and understand exactly where the highway is. So I'm not sure you do have any sort of written material on that. I'm very comfortable that you will understand the position without us needing to make detailed submissions on it, but I do want to make sure you're clear, because if the applicant's position is the highways is shown on the plan, that's just not right as a matter of law. So I don't want you to go off on a wrong basis. No,
understood. I mean, I think at the moment, can we just have an illustration of where the difference between the two parties is?
Yes.
And and I think if we start getting commentaries, then it ends up with effectively the two parties providing a little mini proof about highway boundaries. So can we start just with a plan, please?
We can, sir, but I think at the end of the day you're going to have some submissions on it, because the problem with highways is it's never simple, because there isn't a plan which shows it definitively, and if you're then going to start applying presumptions about the highway extending between the features other side, it's exactly that, it's a presumption. Then you have to look at the facts. So it's not an easy exercise, sir, and I'm concerned that we're going to, or you might find you're in a position where you're determining what the highway is, and if you're going to do that and you feel that it's necessary to do that, then both parties, I would suggest, need to be allowed to make submissions on it, because it's not a simple exercise.
Well, I'm certainly not saying that you can't make submissions on it. And the last thing I wanted to do was to try and complicate matters. What I really wanted to do is just establish in plan form the two parties' positions. Again, I think what I'd suggest is if we could sort of get a plan. If either the applicant or CPPF thinks it will be helpful for myself and Mr. Clegg to understand it a bit more as a separate exercise, can I ask you to speak to each other? Because what I don't really want to do is to end up with going to a lot, as you mentioned, it sounds like it's a complex part of highways law, and in some respects that's slightly tangential to what we wanted the information for, was just to understand the difference between the parties. So if that is to be done, it'd be really helpful if it is possible to have sort of an agreed statement about what needs to be taken into account in order to establish a highway boundary, should that be necessary.
But just before we all go off and do complex amount of work, as I understand it, Mr. Parker can say this is wrong, that the essence of CPPF's point is that you can fit in a scheme without extending beyond the existing hedgerows and features. It's not so much, well, it's all within the highway, but you can fit it in. And our case is, well, you can't if it's in accordance with standards, and that and other factors. I'm not putting it too simplistically. So therefore, where the actual highway boundary is, I'm not sure it's going to help you resolve the issue. But Mr. Parker may I'm oversimplifying it, but trying to.
Again, I'll just make a comment just before you respond, Mr. Parker. And again, apologies, it may well be me using terms like highway boundary that I've confused it in that, because the purple line, as I understand it, is the line that CPPF have drawn based on their understanding of features. So, yeah, perhaps if I take away from our request that highway boundary, just so I can understand. So perhaps if we rephrase this as the area within which the CPPF consider that they've, I'm trying to come up with an alternative description on the hoof, but
yeah, I understand.
Because the last thing I wanted to do was to end up going sort of chasing off in tangents when all we really want is a drawing showing this is CPF's understanding, this is the applicant's understanding.
Yeah, I understand that. I think we can come up with an appropriate label to capture what you're talking about. The other point that occurs to me is because this plan has only come about relatively recently, I'm not sure whether it's the applicant's position that it makes any difference to the arguments that they want to make as to whether the highway boundary or the land within which CPPF want to or say that they can produce their scheme. Because if it doesn't make any difference at all, so if the applicant was prepared to move the red line out to where the purple line is on the CPPF drawings, and that makes no difference to their analysis, with appropriate labelling and understanding of that position, it may be that we don't need to get into exactly where the highway boundary is and where the hedge features are, because all of the applicant's points hold good and none of their points depend on the precise location of the highway boundary compared to the features. Now, that would require the applicant to give us the benefit of the doubt, as it were, that one assumes that one can build within the lines that we've drawn on our plan, with the caveat that the actual highway plan might be different. But it might, I don't know whether that's a way forward which would then avoid any unnecessary dispute about exactly where the highway boundary is or isn't. But
Mr. Cameron.
Well, Mr. Lonergan's evidence was that you can't build within those lines because you need, for example, slopes on the side and so on. So that's our position, but it's not to do with where the highway boundary is. It's to do with how you need to build a road.
In which case, you may not need to know exactly where the highway boundary is. You may just need a plan showing what, on plan form, what we say is the...
Yeah, and again, as I mentioned before, it certainly wasn't my intention to sort of set red herrings or anything like that. It was just to understand in graphic form the difference between the lines, which at the moment we've only got a section, and it'd be really helpful to have that on a plan. I think there's a risk that actually we could keep on discussing that. I think I understand both parties' position on that. Perhaps if I could leave it with the parties, and again with a steer that if this is going into areas where it involves complex. A requirement for complex submissions on law. I don't think that's what we're after. So, in terms of a plan, when's a good time for me to make a note that we should get it?
Well, it's on our side. It's going to involve speaking to Mr. Newman, who's not here today, and I don't know when he's available. So I sounding rather unhelpful, I can't promise a time. I've got to find out when Mr. Newman's available to do it, but I'd hope that we'd be able to do it during this week while CPPF are here. We can then talk to them about it, because we want something agreed to go in, but if we can't do it this week, we can carry on talking about it.
Well, if we say when we open next Tuesday, we'll check to see where we've got to. Is that okay?
Thank you, sir.
The next point I wanted to raise was, Mr. Cameron, the applicants have provided a carbon note. It's titled as responding to an inspector request. Again, this is probably my memory and notes failing me, but I'm not quite sure that we requested it. I don't know whether this was in a response to a question that perhaps we asked Mr. Baker or Mr. Saunders.
Mr. Saunders' evidence, yeah, and it was to do with. Sorry, I don't mean to interrupt across, but we have a note from you dealing with 2 points about Table 1 of his Appendix C, if you might recall, in terms of the interaction between fleet composition, your specific point, and the data in the rows in that table. And then secondly, and we say linked to that, just between November 2022, May 2022, E and F series, and how they are worked out over the assessment period. Now, CPPF had queries on it really arose from CPPF's queries on this, which they've helpfully clarified to us in writing subsequently, and we've recorded those in the note. So we seek to deal with all those points together in the note. The points I've said to you today, and more specifically the points that CPPF have put in writing to us, which we've set out in the introduction to that note, so you can see precisely what they asked and precisely what our answers to that are.
Right, and just a bit more about it. Again, I don't know whether it's just the sort of the timing, but obviously I think the date on the document is yesterday.
That's right, and it was shared with CPPF yesterday as well.
Yes, thank you, and yeah, Mrs. Vincent confirmed that.
Yeah.
And is the intention that you'll be referring to that in your cross-examination of Professor Hurst?
Yes, absolutely. The CPPF have raised these points, and I'm going to put them to Ms. Hurst this afternoon.
Okay. And Mr. Parker, you've got a copy of this?
Yes. Yeah, it's not ideal timing that it came 9 o'clock yesterday morning, but it does purport to address the points that we had raised. Professor Hurst has reviewed the document overnight, and she does have comments about it, and there is two additional documents which relate to the note that they're directly related to the note that the applicant has sought to put in. So I will, in due course, be asking for you to accept that note. I've discussed that with Mr. Henson. It's obviously happening at the last minute. Professor Hurst is arriving this morning. I need time to just discuss it with her and understand exactly what it is she's saying. But the intention would then be to submit the note at an appropriate time to look at it, and then for Professor Hurst to speak to both the applicant's note and her note in response.
And so you...
It's agreed that there is a need to improve accessibility in the Greater Cambridge region to support economic growth, to deliver a sustainable public transport service between Cambourne and Cambridge, and to improve the quality of life within surrounding areas. So, scheme objectives agreed, is that correct?
Yes.
Need to meet them agreed.
Yes.
And the need to improve accessibility and to deliver a sustainable public.
In terms of Cambridge as a destination is not just West Cambridge, it is the biomedical campus, the centre of the city and the north, and therefore my report was aimed at improving accessibility of all those Cambridge destinations, not just West Cambridge.
at accessibility by public transport, in fact by bus, from Cambourne to Cambridge.
Indeed, yes.
And can we also, to see whether there's agreement on this, it's bus delays on the route from Cambourne to Cambridge are such as to necessitate intervention, whether targeted or on the entire route, whether the 2019 or the 2024 traffic figures are used. Is that right?
An intervention is required in any circumstances, yes.
Sorry, Mr. Lee, I didn't catch the end of your reply.
Apologies, I'm labouring a little under a cold and a sore throat. My thinking is not entirely clear either. I'm saying that an intervention is required whether you take 2019 or 2024 figures.
Thank you.
And in terms of the extent of the intervention, and if we go to 4.1.3 on page 11 of your Appendix A, and to the second paragraph, this argues strongly for targeted interventions along the whole route, and then you say that your proposal focuses on Madingley Hill because this is the weakest link in the route for buses. But in terms of your targeted interventions, they're along the whole route, not just Madingley Hill. Is that right?
That is correct, but there was an additional part of the sentence you quoted, which was the weakest link in the route for buses accessing West Cambridge and the M11, that there are other routes for accessing particularly North Cambridge via the A428. But yes.
And in terms of Madingley Hill being the weakest link in the route for buses accessing West Cambridge and the M11, it's not just Madingley Hill, because one of the reasons that traffic backs up along Madingley Hill when it does is because of the movements at the M11 junction. It's the M11 junction movements, as with when you have a link and a junction, it's often the junction which causes the backup. The link isn't the problem, is it? It's the junction.
Entirely right, yes.
And so if you're going to have a solution, whatever you do on Madingley Hill is not going to provide a solution if you don't also do something at the M11 overbridge.
That's not entirely true, because although the cause of the problem is the junction, it causes a queue of traffic, and it is the bus being stuck in that queue of traffic that delays the bus. If there is a bus lane to the front of that queue, then it avoids the delay that it would have incurred by sitting in the queue. So although in an ideal world you would have a continuous bus lane all the way to the city centre, even the GCP, the applicant, is not proposing that. So there is a compromise in terms of where you can provide the segregation and where you cannot. And the scheme before you is segregation into West Cambridge and then through to Grange Road.
But the scheme, the CPPF alternative, doesn't stop at the M11 because, as Mr. Johnston explained yesterday, now envisaged that you would have to build a bridge, an additional bridge.
I'm glad you raised that point, because if you go back to my report, it looks at the route in sections and it analyses the challenges within each section, and the bridge is one of those sections. And the case that I made, and one of the reasons why the report has kind of evolved over time, is because of different assessments as to the feasibility of delivering different sections and the indicated priorities for the applicant in the delivery of the scheme. So, although I'd originally suggested having a discontinuous bus lane, that would have provided a less good quality of service as a fully continuous segregated route, which is the applicant's position. And therefore it seemed reasonable to respond with something which was closer in performance to the applicant's scheme, and therefore to continue the bus lane through to the Park and Ride junction, which is really where the congestion it doesn't end at that point, but that is where it peters out fairly quickly. And so that is what we have put on the table. But nevertheless, the point all along has been that through a process of design, you would decide what parts of that scheme provided you sufficient benefit to warrant the cost and the disruption. And it might be that the applicant, were it to decide to deliver the in-highway scheme, it could decide that building a new bridge or widening the existing bridge is not cost effective, that you could achieve a very similar level of benefit simply by adding an additional lane to the off-ramp of the M11 and using the signals to control the traffic through that. So if you have a bus lane that ends as now at the signals for the off-ramp, you could use those signals to allow the buses a clear run over the bridge as well, with a very high level of performance, not a perfect level of performance, but a very high level of performance, and that probably would be regarded as the most cost-effective solution for that particular segment.
Mr. Lee, the scheme which CPPF put forward and as shown on the civilistics drawings, Mr. Johnson's Appendix F, shows a route which goes across the M11 bridge, doesn't it?
It does, and that was included on the basis that the applicant had commissioned from Atkins a study for the Rectory Farm Bridge, and it set out a number of different options, and one of those options was to add a bus lane to the existing bridge. And I, perhaps a little naively, took it that because it was published in that report by a highly reputable firm of consultants, that therefore it had passed the most basic test of acceptability for safety. I think we've now established that it certainly isn't Mr. Johnson's view that that's the case, and it's not the applicant's view, so I'm happy to concede that that shouldn't have been used as a basis for the design over the bridge, and therefore if one was to continue the bus lane over the bridge, it probably needs another intervention such as Mr. Johnson was proposing.
Thank you, because even that report, the Atkins report, said that the key drawback of this option is that it can lead to higher risk of accidents and greater congestion due to narrow lanes. That's in the Atkins report itself, isn't it? So you knew that at the time you put it forward.
I did know that, but as you'll be well aware, everything in transport is about balancing risks and benefits. There are no black and white so when it says that it increases the risk of accidents, there are lots of things that we do in designing highways that, on the face of it, increase the risk. It just simply raising the speed limit or having a higher speed limit than perhaps it could have been itself increases the risk of collisions and injuries. Those are decisions that are made every day as to getting that balance right. So I didn't see that as this is not feasible and this is unsafe. I saw that as this comes with some caveats.
But now Mr. Johnson has said it is unsafe, you don't pursue it?
Yes, I defer to his greater experience on this matter, yes.
And you mentioned other interventions such as to the M11 slip road. None of the information relating to that, no analysis, is before this inquiry on that point, is it?
No, because as was explained yesterday, although we contemplated commissioning some modelling work, the only model that the applicant could provide is a model that we don't believe is fit for purpose, and therefore it seemed pointless us spending potentially tens of thousands of pounds to produce evidence that actually we didn't have faith in ourselves.
But there is no evidence on the effectiveness of the changes to the M11 slip road that you've mentioned, is there?
You're correct, and I've given my reason why, yes.
Still on principles, and in terms of the figures that you have, and we can look at them, it's figure 2 which you referred to yesterday, still on the principle, for the 2024 traffic movements and bus delays on Madingley Road, they, and this is a statement of the obvious, they don't take account of any movements associated with future development of Bourne Airfield and Cambourne West, do they?
No, indeed, they're historical data, yes.
And as you said, in your oral evidence in chief yesterday, further development will lead to increase in delays.
It will lead to an increase in traffic, and that is likely to lead to an increase in delays. But there are other factors to take into account, and partly people's tolerance to delay, so that people who move into the new developments will make their decisions about where they work and where they send their children to school and so on the basis of the performance of the road network that they find. So it is likely to lead to increased delays, but it doesn't follow automatically.
Likely, and likely to have an adverse impact on reliability, because you don't know when the delay is going to occur, which puts you off using a bus along that route.
Yes, I completely agree, yes.
Thank you. Still on principles, active travel route, leaving aside argument about ancillary and so on, the need for an active travel route is accepted, isn't it? Mr. Littlewood says so in his evidence, correct?
It is, yes.
Yeah. And still on principle, the local plan requirement, and I'm conscious that it's Mr. Littlewood who is he the planning witness for your
yes,
team?
Yes, essentially.
If I call it a team. But if we just turn up, just again on these points of principle, the South Cambridgeshire local plan, which we've got as core document 602, and if we go to page 86, and on page 86, so we don't take it out of context, this is the allocation for a new village at Bourne Airfield, policy SS7, and this is an allocation for, it's not just residential, is it? It's for other uses as well, employment uses included at Bourne Airfield.
Yes, indeed, yes.
And if you go to page 86, we have paragraph 8 of the policy, and then there's a subparagraph A, and this is, so the new village will be founded on a comprehensive movement network for the whole village that connects key locations, including the village centre and schools, to encourage the use of sustainable modes of travel, and includes A, and we have at 1, we'll note segregated bus link from Cambourne to Bourne Airfield, measures necessary at 2 to ensure that bus journey between Caldecott Highfields and the junction of the A428, the A1303 is direct and unaffected by any congestion, and 3, provision of high quality bus priority measures or busway on or parallel to the A1303 between its junction with the A428 and Queen's Road, Cambridge. So the allocation at Bourne is premised and dependent on the delivery of either high quality bus priority measures or a busway on or parallel to that route. That's an essential part of the planning policy, isn't it?
It is, yes.
Yeah. And that element of the policy would be met by the applicant scheme as a busway parallel to the route, or you would say by bus priority measures on the A1303, but you need either one or the other, and it's got to be effective.
Indeed, yes.
So Can we then just turn to the application scheme, still on what I call points of principle? So the application scheme, no, we dealt with that. Is there any dispute that if the order is made, the application scheme will be deliverable?
I'm not aware of any reason why it wouldn't be deliverable, no.
And so can we just see where we've got to? If we have a scheme that is no reason to suppose it's not deliverable, it meets the local plan policy requirement, it meets the need, so is all that correct?
Yes.
So in order for an objector who's in favour of a public transport scheme from Cambridge to Cambourne, which CPPF is, so in order for such an objector to succeed, they would have to show that the current scheme is unacceptable for whatever reasons, environmental and so on, and in order for the need to be met, there's at least a good prospect that an alternative scheme will achieve the agreed objectives and meet the need.
Yes, I think that's a fair summary.
Yeah. Thank you. And if there is no alternative with a good prospect, the aims and objectives with which we have agreed will not be achieved and the need will not be met. It follows.
It does follow, yes.
So your case is dependent upon your alternative being deliverable?
Not strictly. There are other, as my report sets out, there are other ways of providing improved reliability for transport between Cambourne and Cambridge, and one of those is to add additional connections at the Girton interchange. That was something which Smarter Cambridge Transport, the organisation I led, proposed in early responses to consultations, and GCP rejected that on the grounds that it was part of the strategic road network and it didn't have the powers to intervene. The reality is it does have the powers to intervene, as Essex County Council has demonstrated in building Junction 7A east of Harlow. So it is a choice that the applicant made to not pursue that, but that actually was probably the most popular intervention that was supported by business and community. So in terms of meeting the plan requirement, plan policy requirement, that too would probably achieve it. But at the moment that is out of scope.
Well, would that be a scheme parallel to the A1303?
It would, because it would be using the A428, which runs parallel to the
It's between the A1303, between its junction with the A428 and Queen's Road, Cambridge.
Yes.
It wouldn't be parallel to that route, would it?
It would achieve the same objective, which is to remove traffic off the A1303 so that it becomes uncongested and takes the through traffic that is getting between the A428 and the M11 off that road, and it would also allow buses to go to the biomedical campus, for instance, without using the A1303.
But there is no such scheme before the inquiry, is there?
You're correct, there is not.
And there's no funding for such a scheme?
Well, the GCP could allocate funding to it. It has discretion.
It hasn't done so?
It hasn't done so, no.
Now, moving on from those matters of principle, just before we get into the detail, I'd just like to ask you some questions about your experience. And Mr. Clegg asked you about your position at North Hertfordshire Council, and you're not here obviously on behalf of North Hertfordshire Council, which you clarified, but I'd just like to understand what your professional expertise is. You were on North Hertfordshire, they're a district council, are they?
That's correct, yes.
And are they unitary or is it a two-tier?
No, it's a two-tier authority.
Two-tier,
System.
and Hertfordshire County Council are the highway authority?
That's correct, yes.
And so the district council for which you work is not the transport authority for its area, is it?
It isn't, no.
And when you are involved in preparing policies in terms of your day job for the North Hertfordshire Council, you're not preparing or advising on policies in a transport plan because North Hertfordshire don't prepare that. So are these planning policies that you're advising on?
So I represent the district in discussion with the Highway Authority on its policies, including its next local transport plan. But I also write and advise on policies which are within the remit of the district, which are primarily planning policies, as you say.
So it's when you say that you have responsibility for developing transport policies and strategies at 2.1, the policies which your employer is responsible for are transport policies which form part of a local plan or planning policies, not a transport policy, is that right?
Yes, but I am also involved in the formulating of transport policies at the Highway Authority, the Hertfordshire County Council.
And because we're going to get on to tag and so on later, in a professional capacity while working for North Hertfordshire, have you been responsible for the development of business cases for major transport projects undertaken in accordance with Treasury Green Book and tag? And I don't mean have you contributed, I mean have you been responsible for?
No, okay.
And in terms of highway engineering professional qualifications, that was Mr. Johnston. That's not your field of expertise, is it?
That's correct.
Can I also understand the basis on which you're giving evidence? Because you, not acting for CPPF, but as an individual, you've made an objection to the order, haven't you?
I did, yes.
We got it, it's CD2 OBJ 231.
Indeed, yes.
So, as an objector, you don't give evidence to this inquiry as an independent expert, do you? Because your position is set out in your objection. So you don't come as an independent expert. Is that correct?
Sorry, I don't quite follow the logic of your question.
An independent expert comes, as the word independent suggests, without a personal position and comes under a duty to assist the inquiry, whether it advances their client's case or not. Whereas somebody who's made an objection has already decided which way their views have fallen on the project. So you can't act as an independent expert if you're an objector, can you?
I understand the point you're making. I wasn't aware that I was creating a conflict of interest by submitting a separate objection. My own objection aligns with the position of the group that I am representing here today, so I don't see that I've created a material conflict, but I understand that there is a technical conflict, and I accept that.
Yeah, I'm not suggesting there's anything improper, I'm just trying to understand the basis on which you're here, but you're somebody who's formed a view on the scheme rather than an expert who's instructed and then forms a view and has a duty to the inquiry.
Yes, that is correct, yes.
So let's just turn to, next heading is alternatives, and well, let's just turn to your appendix A to your proof and go to page 7, please. And this is part of 3.5 alternative proposal, and it's 4 paragraphs up from the bottom. The paragraph that begins, "Our proposal is a variation of."
Yes, I have
You're
that.
very swift on finding documents. Give you credit for that. So you say the CPPF scheme, that's our proposal, is a variation of low-cost option B in the options appraisal report. I think we looked at it yesterday. I think option B may have been the central inbound lane, and option A was the near side. This, I'm not taking a point on whether it's A or B, but do you accept that the broad option that CPPF are advancing has been considered by the applicant as part of the options appraisal process?
Yes and no. So yes, the principle of it has been considered by the applicant, but as I tried to explain yesterday, we don't believe that the applicant has seriously and collaboratively engaged in designing a deliverable scheme within that corridor, and that the parameters that it has chosen to design such a scheme have almost automatically ruled it out, rather than taking it a step further to demonstrate that actually it truly is not deliverable. So in that respect, I don't believe the applicant has fully considered that option.
But what you do agree is that the broad option has been considered. It's just the way in which it's been considered that you think is inappropriate.
Yes, I mean, I think one of the, in correspondence over the years, I think the principal reason for choosing the scheme that's before you today is that it maximises journey time benefits rather than necessarily optimises. So I think there was a preference to have a fully segregated busway, irrespective of whether there was a feasible scheme within the existing highway that was inbound only. So I think the reasons for ruling it out were not actually technical, but the argument now is that it is technically not feasible to deliver something within the highway. But I don't think that was the reason it was ruled out of the options.
But in terms of the options considered, we have the option appraisal report, which does have an inbound near side bus lane. We agreed on that, whether it's called A or B.
Yep.
And also, I'm sure you're familiar with it, but we have a technical note, which is our core document 1307, and that is the Mott MacDonald note. And Mott MacDonald were expressly asked to consider an on-road scheme, and that's exactly what they do in that note, don't they?
They do, but as I just said, it's with parameters which almost by design rule it out from consideration by not accepting any departures from standards or any adjustment to the kind of the realities of what's on the ground.
But in terms of it, perhaps we can agree this, and I think this is your position and Mr. Johnston's position, that it's not possible to have a scheme which meets standards, particularly as to lane widths, without causing harm to ecological and heritage interests. And that's the problem with the on-road route, isn't it, if I can put it that way?
Yes, I think that's entirely fair, yes.
So let's then go through we're not going through the whole history, but I'd like to just go through some of the history of the development of the scheme, because it's what you've tried to do is to address that problem. That's what you've, and we'll see how you've done it. So can we start some way back, and I'm not going to spend ages on the history, but it is important that we investigate it. Can we start with a document that I'm not sure we've looked at yet, but this is core document 1003, and we need to go to page 6. It actually goes to one of the points you just made. So we go to page 6. This is a meeting of the GCP Executive Board, minutes of the meeting held on the 13th of October 2016. It's quite a long time ago, but there's been quite a long gestation to the project. And we have there questions by Edward Lee. I don't want to be unfair about this, but was that you or some other Edward Lee?
No, that was me.
Yeah. And if we look at the second paragraph there, he, that's you, was of the view that to have congestion-free public transport, the solution could only ever be a segregated bus or rail route, and felt that the project brief should instead have set targets for modal shift. So it comes back to the very point you've just been making, that if you want congestion free, you need a segregated route, if that's the objective.
Yes, but congestion free should never be an objective for a transport scheme, because it's the cost is disproportionate to the benefit that you achieve. So the point that I was making there is that actually the objective should have been set in terms of transport outcomes rather than a kind of means to an end, which is the congestion free. In other words, you could have a small amount of congestion, a small amount of variability in journey time, and it would have negligible impact on patronage, and therefore it is fair and reasonable to set a balanced target that gets you the outcome which you're looking for, which is people using the bus.
Yep. And that's the optimising, not maximising.
Indeed, yes.
But of course, if it's not congestion free, one of the compromises you have to make is to put reliability into question.
Reliability is always in question, even if you have a fully segregated route. Buses break down, trees fall on the road. They need to be repaired. So you can never, ever, under no transport scheme can give you 100% reliability. So the question is always what level of reliability is acceptable, and the measure of acceptability is really when it starts to significantly impact patronage.
Yeah. And do you agree that you're likely to have a more reliable system on a segregated route, because you only have to deal with your own problems, not problems caused by others?
Yes, although it's not entirely true that you don't get problems from other people. I mean, people stray onto busways, so the problems are not entirely within your control as the operator. But yes, you're right in principle that an exclusive use of a piece of infrastructure gives you higher reliability.
And so just going through the history, so that was a contribution you made in 2016. We then get to 2021, and at this point you were commissioned to author a report setting out a conceptual design. That's in your proof at 314. And that is the February 2021 report, is it? Is that the first report in the series?
Yes, I actually thought it was July 2021,
right. But go to core document 710. I may have got the date wrong, but if we go to 710, at the top, I mean, it doesn't matter whether it's July or February to me, but it says February at the top.
Okay. Yes, that was commissioned by CPBF from me, yes.
Yeah. And so, but that's the first in the series. We don't need to go back any. There's no earlier report, is there, from you?
There isn't an early report from me. There are responses to consultations that I wrote for Smarter Cambridge Transport, from which I drew the ideas that are presented in that report.
And if one, and this is the report, is this the report that went to the auditor?
Yes, to the independent auditor, yes.
And if we just look at the executive summary, we'll just see what it is, page 2, that was being proposed at that stage.
Sorry, could you just remind me again of the document reference?
Yes, 710.
Right, yes, sorry, yes. Yes, sorry, and I see it is dated February 2021.
At this time, if you look at the second paragraph, the executive summary, both East West Rail and CAM are able to provide a high quality public transport scheme serving the Cambourne area in the medium and long term. This creates the opportunity to consider in-highway improvements to bus services and active travel, which could meet short-term needs. In the medium and longer term, also provides access to locations that will not be served by the new railway or CAM. And this report identifies some of these opportunities and estimates the bus journey time savings they could achieve. So at that time, you were considering and looking at short-term solutions. Is that right?
Yes, but I don't want to exaggerate how short. I mean, I think we were talking about in up to a decade sort of time frame. Yes.
And we can see at the end of the bullet points, says we have therefore focused on measures that may be implemented relatively quickly to reduce delays to inbound buses from Madingley Mulch roundabout to the Park and Ride junction. And that's the Madingley Park and Ride junction on the eastern side of the M11.
That's correct, yes.
And so at that time, and if we look at the end of the executive summary, this solution was put forward as part of a package of quick win interventions as an effective low-cost interim solution, while the details of longer-term infrastructure schemes such as East West Rail and the CAM network and the Girton interchange are worked out. So put forward as an interim solution.
Yes, and I think it's still, I would still propose it as that. I don't think an inbound bus lane along the Madingley Hill does not meet all of the requirements for connectivity to the city, and East West Rail is still progressing, and the Girton interchange is still a problem that needs to be fixed. So I would still stand by that.
But at the time, interim, which you stand by, the CAM network was contemplated, and that CAM network, and we may be just worth getting this up as well. If you go to core document 738 and go to page 12, and there's a diagram on page 12. So obviously a previous scheme which now not pursued, but just to see the context, the CAM network, which was part of the medium and longer term solution, that included a service to Cambourne, didn't it?
It did, yes.
Yeah. And so if we're looking at the context for your interim solution, it contemplated CAM, which had a service to Cambourne. That's now been shelved, abandoned, CAM, has it?
It is true that the CAM was the proposal of the former but one mayor, and it was abandoned by his successor. But I understand that the current mayor is seeking to revive a new light rail network that would perhaps be similar to the CAM scheme.
But at the moment, no proposals for that.
No.
So what we have as your alternative, the on-road scheme, is what was originally proposed as an interim solution, which contemplated that other measures would come along in the medium to long term, and those other measures were CAM and East-West Rail, but CAM is no longer coming along.
No, but as I said, the current mayor was elected on a manifesto to deliver a light rail network, and he's engaged professionals to help him develop that. So I'm not. You're right that the CAM network is not progressing and is not on the table, but East-West Rail is, and the Girton Interchange could still be a scheme were the mayor and National Highways to choose to pursue it. So the statement I said that it's a low-cost interim solution while the use of longer-term infrastructure schemes still stands. Even though those longer-term schemes are not yet committed, there is at least one in the pipeline.
But one of the longer-term schemes that you had in mind at the time was CAM, which would have provided and that blue line is in fact it's a bus service to Cambourne, isn't it? The CAM service.
Well, actually, CAM never quite resolved what types of vehicles were going to run on this segregated route. So,
A segregated route to Cambourne.
Yes.
And so the interim solution you proposed was proposed on the basis that there would be, in the longer term, an alternative segregated route to Cambourne. Correct?
Yes.
Okay. And sorry, just give me a moment. So, and then if we see what the auditors said in response to that report, because we've still got the 2021 report to hand, and if you go to core document 827, and if one just goes to page 75, there's a reference there, 7.3 key findings, preferred route option. And the auditors did consider an online scheme of bus priority measures along the A1303, which was the scheme which you and maybe others put to them, wasn't it?
That's correct, yes.
And what they said was that the in-highway proposal for high-quality public transport along the A1303 are essentially short-term measures that are consistent with the C2C scheme objectives. So, and that's the basis on which you put it to them, wasn't it, as a short-term measure? So they correctly understood that.
Yes.
And then they said, however, this does not invalidate the assumptions and constraints for the preferred option as a long-term solution to meet the growth in travel demand along the corridor. And the proposers of this option acknowledged that a longer-term solution is required and proposed that this can be provided by the CAM network, although this approach may no longer be available. As this now looks uncertain, the case for the on-road scheme is weakened, but not entirely without merit. And do you agree that the case for the on-road scheme is weakened because the CAM proposals are no longer on the table?
Actually, no, because East West Rail at the time was not the government was not as committed to East West Rail at that time than it is now. So actually, in terms of those future long-term higher capacity, higher reliability transport infrastructure schemes, East West Rail is the replacement, if you like, for CAM in terms of what was most likely to be delivered, and that will provide that, as I say, that higher quality, higher reliability, higher capacity transport link from Cambourne to other destinations in Cambridge.
But that's not consistent with the way that you put it in your original report, is it? Because in your original report you contemplated both East-West Rail and CAM, not just East-West Rail.
Yes, but the world's moved on, and now East-West Rail is the one that's more likely.
Yes.
That's not to say that there might be a case for building a more resilient segregated connection to West Cambridge from Cambourne, but our position is that the case for that is not made to go beyond what we're proposing. But in the longer term, it may be that this mayor or a future mayor will seek to deliver something that is more like the CAM link that connects into a tunnel and provides connectivity to the more of the city than East-West Rail or our inbound bus lane would.
But when you first came up with this scheme, it was envisaged as a short-term solution, correct?
Yes, but as I say, let's not get hung up on what short-term.
Yes.
That could be anything up to a decade or 15 years or whatever it takes to develop a East-West Rail or other larger infrastructure schemes.
As short-term, up to a decade, and it was also envisaged that amongst the longer-term solutions would be CAM, which is a segregated route, would have provided a segregated route from Cambourne to Cambridge.
Yes, that's correct, yes.
Okay. Now we're going to move on. So that was 2021.
Sorry to
Yes.
interrupt. Can I just check, have you got enough water, Mr. Lee, in your water bottle?
I have. Fine, thank you.
So I just want to make sure that...
Thank you.
Sorry.
And so shall we go, if we can, to September 2024? There were other iterations of it, but I'm going to go. So this is core document 709. And this proposal was an inbound central bus lane. Is that correct?
For some of the route, yes.
But the bit on the A1303 that goes past the American Military Cemetery and Madingley Wood, SSSI, was an inbound central bus lane.
I did suggest that, yes.
And we know that Mr. Johnston considers that would not be safe. That's what he told the inquiry. We also know that Mr. Johnston was instructed in November 2023, he told us. So when you proposed this inbound central bus lane, did you do so contrary to Mr. Johnston's advice, or did you not seek Mr. Johnston's advice? How did it arise?
So this essentially hadn't changed from the earlier 2021 report in that respect. So no, I hadn't sought Mr. Johnston's advice, and he hadn't offered it in terms of suggesting that this wasn't an appropriate or safe way to design a bus lane on a road.
Yeah. And at that stage, it was suggesting adding a near side bus lane to the M11 overbridge, wasn't it?
Yes, I mean, there was already a near side bus lane on that section. I had only suggested a central one on the western part of it. But yes, Mr. Johnston's advice was that it would be more deliverable to have a continuous near side bus lane.
And so you put this forward, and WSP reviewed it, and we have this core document 931, and they came up, if you go to page 39 there, with a list of non-compliant aspects. Page 39 and page 40, they raise road safety concerns.
Yes, I have that.
Now we know that the central bus lanes are no longer pursued. Mr. Johnston considers them to be unsafe, and you had the benefit here of WSP's views, and that central inbound bus lane is no longer pursued, is it?
That's correct.
And so in April 2025 we have the report submitted with the statement of case, and that had an inbound near side bus lane, and we know that at that stage was Mr. Johnston involved in drawing up the design.
I think we had discussed it, but I don't think he had reviewed it in detail. I think we involved Mr. Johnston in the briefing of civilistics in drawing up the scheme, and I think that his focus was on ensuring that that technical drawing was something that he was happy to submit as part of his proof. So I can't speak for Mr. Johnston in terms of how much of my report he wrote, but in terms of our discussions and the brief to him, it was really to get his professional input to the technical drawing.
And that was the drawing that was produced in July 25 after this April report.
That's correct, yes.
Because the April report you referred to and appeared in part to rely upon Active Travel England's absolute minimum cross-section, which Mr. Johnston, it's not something Mr. Johnston relies upon, and I asked him about it, he's not familiar with it. Was this you who came up with that?
Yes, that was me, yes.
And you will have seen that the applicant in their assessment at CD 931, and I'm sure you've read this, we can turn to page and paragraph if we need to, but they looked at the user manual for Active Travel England. There's a tool that you use, and they couldn't find a drop-down box for a road such as Madingley Road. So is this the Active Travel England, which is this for different types of road?
I don't think the toolkit is all that clear, to be honest, as to precisely what roads it is suited to. Active Travel England is primarily promoting infrastructure that's safe for cycling. It's not a highways. It's not a part of the DFT that's primarily concerned with highways. So it is even possible that their advice in some ways conflicts with DMRB, which is a pure highways standards.
So anyway, that scheme's not pursued because you came up with the civilistics scheme July 2025, and that is the one that found its way into the evidence.
That's correct, yes.
And by the time the civilistics were instructed, and this is July 2025, and by the time that you put forward the scheme which is appended to your evidence, you had the WSP July 2025 report, didn't you? By
Yes,
August,
I believe
you
so.
had it.
Yes, I believe so, yes.
So you had the applicant's response, and if you go to that document, CD 931, do you accept, and we can go to page 42, 3.5, that the applicant's consultants didn't limit their report to criticisms, but they developed their own alternative concept designs? So it wasn't a completely negative document, was it? An alternative concept design was developed. So page 42.
Yes, but it was using DMRB standards, which,
Yes.
as we've explored with Mr. Johnston, are not well, in his view, they're not your starting point for a design, but in any case, they are not rules, they are guidance that can be departed from. So, yes, they did attempt to design a scheme, but it is using parameters that almost prove before you start that it cannot be accommodated within the public highway.
Yes, because if you do design it to DMRB standards, it can't be accommodated within the public highway, and it can't be accommodated without causing unacceptable harm to heritage and ecological assets. Is that right?
Well, the unacceptable is a subjective planning judgment.
Yes.
It's not an objective judgment, but yes.
Well, we're going to come on to the instructions that you gave to civilistics and see your view on that, your subjective view.
Yep.
And so you had, at the time, you had the view of the applicant's consultants as to, so if you 3.5, they did an alternative design, 3.6, they set out road safety concerns associated with the near side bus lane. So all this was, and then 3.7, engineering difficulties. All this was available to you when you came up with your August scheme, correct?
Yes.
Yeah. Now, we're now going to get to instructions that you gave to civilistics. And if we go to your proof, and we go to 5.2, now this is where you say design decisions and departures from highways and active travel design standards have been agreed between civilistics, Mr. Johnston, Mr. Woodfield and myself, where it was believed it was appropriate to reduce ecological harm, and these included, and you have a list. Now, and this is where Mr. Johnston referred to the advice from the environmentalist.
Yes.
And that's Mr. Woodfield, is it?
Yes.
So when did these discussions that you referred to at 5.2, when did they take place? I'm not asking for precise dates, but this is post-April 2025, when your statement of case went in, but before civilistics were instructed, so sometime between April and July 25.
Yeah, yes, and there were ongoing discussions. I mean, as it says, it's between civilistics, so it was after we had commissioned them, and that we had discussions with them. So we gave them a brief, but then had discussions, and they took input from Mr. Woodfield and Mr. Johnston.
And this brief that they were given, what Mr. Johnston explained was that the parameters were set out on the basis of the advice of the environmentalist, and then Civilistics, guided by Mr. Johnson, had to come up with a design within those parameters.
Yes,
That's what Mr.
essentially,
Johnson
yes.
said.
Yes,
Is that your
essentially.
recollection?
Yes, yes.
And so the parameters, coming back to the planning judgment as you put it, the parameters you set, were they set so as to avoid unacceptable harm to ecological and other relevant interests?
Yes, so the decision about the lane widths was the product of discussion between all parties as to what we thought was probably the right balance to start a design with.
But the right balance to start the design with was to set parameters. Mr. Johnson says by the environmentalists, but it's you with Mr. Woodfield taking a view on the corridor within which you felt a widened road would be acceptable.
Yes.
Correct. Yeah. So in arriving at that corridor, you took the view that a wider road would be unacceptable for some reason, ecological.
Well, again, it's a starting point, and ultimately the design would seek to balance road safety, functionality, and ecological harm. So Mr. Woodfield's judgment is not the last word in what trees must be kept. And the process of design would seek to explore that to get that balance right. And similarly, clearly there may be points where the lanes need to be widened, and that would be part of the discussion between all parties in getting the right balance in the design.
But what Mr. Johnson said was that the parameters were set by the environmentalist. Is that correct?
No, they were set jointly, but it was Mr. Woodfield's advice about the most ecologically sensitive parts of the road that we should seek to avoid harming. That was our starting point.
And so avoiding ecological harm, were heritage harms also taken into account?
Yes, and we were mindful of the setting of the American cemetery in that respect. And we sought to minimise the harm there, and one of the decisions that was made on the recommendation of Mr. Johnson was to move the actual travel path to the north, so that it was that ran alongside the cemetery through the verge, because we felt that was probably, certainly in our judgment, would cause less harm to the setting than moving the road closer to the hedge and the setting of the cemetery.
So heritage taken into account, and can I also ask you to take up core document 10616. Now this is the we've looked at this already in the inquiry. This is, I want to go to page 8 to begin with. This is the letter from Anthony Eden to the American ambassador.
I have it, yes.
And you will see that if you go to page we've looked at this before, but if you go to page 9, there are arrangements at E shall be made by Her Majesty's Government so that during the time such time as the area defined in pink on the map is used as a cemetery, the area coloured yellow will be restricted to agricultural use, and the American Battle Monuments Commission will be consulted about any proposal to develop the area coloured blue. And then we look at the map on page 11, and we can see the extent of the area coloured pink, which is the cemetery, and the area coloured yellow. Do you have that?
I do.
Page 11?
Yes, yes.
And we see that the American ambassador, page 12, responds to the letter, and at the bottom, in reply, I have the honour to confirm that the conditions set forth in your note are also acceptable to the government of the United States of America, and that it agrees with your suggestion that your note, including annexes thereto, together with the present supply, shall be regarded as constituting an agreement between the two governments in this matter, which shall enter into force as from today's date. Now that matter of law I don't ask you about, but that's an agreement between two governments. It's an international treaty.
Mm-hmm.
Did you take this into account during your discussions?
I am aware of this document, and I think the question is the precise extent of the land that constitutes the road through it, and therefore whether any widening of the road would encroach into either of the areas that are shaded pink or blue. My presumption would be that the land owned by the County Council as the Highway Authority is not shaded, and therefore, provided a scheme can be delivered within the public highway, the adopted public highway, then it wouldn't encroach on the terms of the treaty.
But the scheme that you're promoting, you're not suggesting promoting a scheme which would intrude into the areas protected by the treaty, are you?
Absolutely not.
And do you accept that that imposes a constraint on what you can do along this road?
Absolutely it does, yes.
Thank you.
Mr. Cameron, I'm looking
Yes.
for a convenient time for a break around sort of 11:15. Is this it, or do you need to carry on later?
That is it. I know barristers always say that because they like breaks, but in this case it is.
Thank you. Yeah, so I think it's 11:15. It's 13 minutes past 11, and we'll return at 11:30. Thank you.
In terms of your approach, you set the parameters for the designer by making assumptions and judgments as to what is acceptable harm, haven't you? Because the parameters were set for your designer.
Yes, those are preliminary judgments. We're not, no one of us has set a parameter that could not be varied.
Yeah. And as far as the en route option is concerned, what we know in the light of Mr. Johnston's evidence is that when it gets to the M11 overbridge, you need to either extend the existing bridge or, as he suggested, put in a new bridge next to it. Correct?
Yes, and it should be pointed out that the existing bridge is not standards compliant, certainly in terms of its provision for active travel. The width, the separation from the road, and the parapets. So there is potentially an argument for moving the active travel path off the bridge in any case, and then that would release land potentially to put in the bus lane. But that would require further detailed work.
You still need a new bridge, you need compulsory purchase, and you need National Highways to sign up to it.
Well, you need National Highways permission to do any work there, but that doesn't mean they have to sign up to it, because they wouldn't be paying for it.
That was imprecise term. They would have to agree.
They would indeed, but there's no reason in principle why the National Highways would refuse consent any more than to build the bridge that's required for the C2C scheme. And it may be possible, and I think one of the options that the Atkins report shows is essentially kind of what you might term the clip-on arrangement, where you extend the existing bridge with an additional structure that wouldn't require the same level of interruption to the motorway below.
But whatever the solution, a solution is required. It's not worked out at the moment, and it's not known whether National Highways would agree to it, is it?
Well, you say it's not known, but there is no reason to believe that National Highways would refuse. I think the more pertinent point you're making is that we don't know about the land ownership on either side to create the approaches to a new bridge, and that, I think, is probably the more pertinent point. But as I said earlier, there is an argument that you leave the bridge exactly as it is and you use traffic lights to regulate the flow of traffic over it, and not try to build an additional bus lane across there.
But again, that, as we've been over, has not been modelled.
You're right, yes.
So we're now going to move on from the CPPF alternative, apart from one point, and that is costs. And if we go to your Appendix A, page 7, and you there do some preliminary sums, and you say it's the same bit we looked at 4 paragraphs up as before. Our proposal is a variation of low-cost option B in the option appraisal report, which included a park and ride at Scotland Farm. The estimated cost of that option was 37.7 million in 2018 prices, and you've applied a contingency and applied inflation, and you get 62.5 million. And is that what you're suggesting the scheme that you put forward would cost?
No, not precisely. So the whole scheme in that options appraisal obviously extends all the way to Cambourne and involves interventions through Bourne Airfield and so on. So that's included in that, and the park and ride. So it is a first attempt at estimating the total cost of the scheme that includes an in-highway bus lane rather than a segregated route from Long Road.
Well, I think you've answered my next question already, but let's just see, because the 37.7 million figure that you referred to, that comes from the option appraisal report, is it? Is that where you got it from?
It is, yes.
So if we go to, and that was low cost option B, if we go to core document 1-20-08 and to page 82, and there's a table there, table 18. And that's where the 37 million comes from, isn't it? Well, that's when, well, one can find it. Sorry, page 82. If
Yeah, I'm just going to note it's taking a moment to load.
yeah,
but
it's
yes.
48 megabytes or something.
Yes. So I'm up, to
Page
70,
82.
I'm up to 78, sorry, it's just
Well done.
coming to 80.
82.
Yes, I'm on page 82 now, yes.
Table 18, low cost B, 37.706 in that table.
Sorry, I'm on page 82.
Yes. Of core document 1-20-08.
Yes.
Page 82 in the PDF, sorry.
Oh, right, sorry, yes. Sorry,
75 in the
printed page.
paper.
Yes, I'm
Table 18.
table 18, table 17, table 18. Yes, I'm there now, yes.
So there's a column headed low cost B,
Yes.
total 37.7, which seems to be the 37.7 that you're referring to in your
That is correct,
evidence.
yes.
And that, so we now need to look at what is a low cost option B, and we need to go to 4.2 in that document, and we can see do something low cost B.
Which page are you taking to?
Page 37, sir. Apologies, I didn't get the page number. So we've got completion of recommended on-road phase 1 and park and ride at Scotland Farm. So if it's phase 1, it's east of Madingley Mulch roundabout, but with Scotland Farm park and ride, isn't it?
It is, yes.
So you'd have to, if you're going to do a like-for-like comparison, which you've sought to do at page 7 of your report, you shouldn't be comparing the 37.7 inflated up to 62.5 with contingency with the 192, because you're not comparing like for like, are you? You're comparing the cost of part of the scheme with all of the scheme.
You are correct, and that is my error, yes.
And also, one would have to, well, I'll ask you this, does the 37 million, we have phase 1, so we've got it is going to Grange Road from Madingley Mulch, so it goes over the M11.
Yeah.
So it's got that bridge in, but we don't know how much that bridge would cost compared with the cost of the bridge that you would need over the M11.
If we do indeed need a bridge, but yes, you're right that would need to be factored in.
So, not a like-for-like comparison.
No, that's a fair point.
Okay. Can we then go to Cambourne Greenway? Now, are you the right person to ask about the Greenway, or is that for Mr. Littlewood?
I think we're probably both competent to answer, but we may have different areas of... Right.
Now, the Cambourne Greenway put forward by CPPF and Coton Parish Council as an alternative active travel route to Cambourne. That's the reason that you're referring to Cambourne Greenway, isn't it?
Yes, but to be clear, obviously the agreed Greenway route only goes as far as Hardwick.
Yeah, well, that's you've answered the question. You say it only goes as far as Hardwick. I mean, if we get core document 2915 to hand, it's that brochure. And in fact, at the moment, if you look at page 2, it doesn't, the thick green line, which is the shared use path, that goes to Cambourne, as the name suggests. It's the Cambourne Greenway, and you've got a dotted line going to Hardwick, and that part of the route is subject to landowner agreements, so can't even be sure that it goes to Hardwick, can we?
There is a public bridleway along that connection between Hardwick and Long Road, so the uncertainty is about whether a better route can be agreed with the landowners.
And whether it can be up to the standard of the rest of the route.
Yes.
Yeah. And this route, and it doesn't go to Cambourne, as you've said, and it's intended, if we look at this map with the annotations on it and plan, if you look at Grange Road, this scheme has been devised, that's the Cambourne Greenway, with the Cambourne to Cambridge project in mind, hasn't it? It's not been designed as a replacement, it's been designed assuming that Cambourne to Cambridge goes ahead, because if you look at box 12, proposals on Grange Road will be minimal, but tie in with proposals for the Cambourne to Cambridge project. So
what is shown there is using an existing route through the West Cambridge site. So it isn't showing or relying on delivery of any of the Cambourne C2C busway scheme.
Not suggesting it's relying on any part of it, but the question I put to you, it has been designed as an additional scheme, not as a replacement for any active travel route on the Cambridge to Cambourne busway scheme. Is that right?
It would be bizarre for an organisation to disown part of its own project, but yes, it acknowledges that there is another scheme, but nevertheless there is a slight oddity that it is providing two parallel routes in close proximity and providing infrastructure for both, when there probably isn't any demand for that level of capacity.
You say that, but they're going to two different places. One goes to Cambourne and perhaps on to Hardwick, and the other goes to Cambourne.
Yes, on the west side, but you were drawing our attention to the connection to Grange Road. But yes, going west from Hardwick, as was identified in I think in the cross-examination of Mr. Lonergan, we were looking at the local cycling and walking infrastructure plan, which shows an aspiration to extend the Cambourne Greenway west to Cambourne. And that is also part of the aspiration for the Bourne Airfield development, which has identified points of access for active travel routes in the southeast corner.
But even that plan, the local cycling and walking infrastructure plan, even that, and it's Mr. Littlewood produced it at page 21 of his evidence, a screenshot, so 21 in Mr. Littlewood, which is CD 26-10-W1-1.
Yes, sorry, which page?
21. So
Yes, I have it.
there, so the Cambourne Greenway going to Hardwick, that bit shown as indicative, not certain, correct?
The indicative means that the precise alignment of the route is not yet agreed. It's not indicative in the sense of it's uncertain.
And then if you go on the blue, the LCWIP, that's a cycle route indicative. Again, indicative, not finalised.
Indeed, but the indicative is not that it's uncertain that it is needed or that there's any about the desire to deliver it. It is indicative because a route along the ground has not yet been identified and agreed.
Exactly, hasn't been agreed, and as we saw before on the Cambourne Greenway brochure, partly because it's subject to landowner agreements.
No, it's not.
Well, that's what it says on the document, doesn't it?
Yes, but just to go back to the link to Hardwick, that is not. It's not entirely subject to landowner agreement because there is an existing public right-of-way and a bridleway. I've cycled along it. It could be turned into a cyclable route. So the uncertainty is about whether a better, more optimal route can be achieved through private land by agreement with our landowner. But there is essentially a fallback position of using the existing public bridleway. And that extends further west to Highfields Caldicot. And then there are points of connection from Highfields Caldicot to the Bourne Airfield development.
Yeah. But that compares with the applicant scheme here, which, as an adjunct to the busway, offers to provide an active travel route which will take you direct from Cambourne to West Cambridge. And that will be for a cyclist who's using it for commuting, will be a direct route, won't it?
It would be a direct route for some people. It really depends on where you live in Cambourne or Bourne Airfield as to which would be the more appropriate or more desirable to take, and also your willingness to cycle up hills.
Yeah. But cycle up hills on a dedicated route rather than along a bridleway.
Well, it would be an
hill.
It would be an upgraded bridleway, so it would have a proper surface and stud lighting and so on. So a similar experience.
Yeah, but the Cambourne Greenway is designed as a route which has not been finalised, and it's a different type of route to a route which takes you direct, one form of direct route, as you say, along the side of a busway, where if you're a commuter, you're probably more interested in how quickly you get there rather than how scenic the route is, are you not? Depends on who you are.
It's very much so, and how much effort you want to make, and whether you like cycling alongside. So some of that route is on road, as you know. It's through Hardwick Village. It's on road, so it would be a point of personal preference if you had a choice as to which was the one you'd use.
Let's turn, if we can, to a different subject, which is criticism of the applicant's analysis in the economic case. And I'm just going to ask you some questions on approach and A business case, or an HM Treasury Green Book business case, provides the basis for investment decisions, and that is investment of public funds in different projects, but for the DFT, for transport infrastructure projects. Is that correct?
Indeed, yes.
And that is not, it doesn't give you a definitive answer as to whether or not to make a TWA order. The purpose of the business case is, do you get the money to pay for it? That's the purpose of it, isn't it?
It would in some circumstances, but actually in this circumstance, no, it doesn't, because the GCP has the authority to allocate that money with or without the business case, so yes.
You're right about that, but the purpose of the business case is to inform public sector investment decisions.
That is its general purpose, yes.
And the economic case is one element of the business case.
Indeed, yes.
And going back to your answer just now on the GCP, the fact that the GCP have power to allocate the funds removes a source of uncertainty, because we know that the funds will be allocated.
Yes.
And the value for money framework is not limited to monetised benefit cost ratios, and as I put to Mr. Johnson and he agreed, it requires a holistic approach, and you would agree with that, would you?
I would, but I would say that the economic case is the primary pillar. That's the most important pillar of the case. But you would also take into the other four components of the business case in arriving at a decision.
Yes, but the question was about the value for money framework, which is one element. That's the part of the economic case.
Yes.
And the economic case, which is one pillar,
yes.
Even the economic case itself is not limited to monetised benefit cost ratios, is it?
I'm not quite sure where you're going with this, because almost by definition, the economic case is an attempt to monetise all benefits. There are some benefits for which there isn't a methodology or an established and agreed methodology for monetising, i.e. converting into a monetary value. But nevertheless, that is the aim of an economic analysis.
Well, shall we go to core document 8.32 then, and you'll see where I'm coming from, if not going to. And this is the document headed Value for Money Framework.
Yes.
And it says at 1.1.3, the framework sets out, on page 4, a holistic approach to value money, ensuring the assessment takes the full range of impacts of proposals into consideration, not just monetised benefit cost ratios. It draws on best practice within DFT and across government. So it's not just the benefit cost ratio, is it?
No, I'd say not.
Good. And I think we can also agree, and Mr. Johnson agreed, that the business case analysis is not a substitute for the overall planning balance.
No, they are separate.
Now, I'm not going to take up every point of criticism that you make of the business case, but doesn't mean to say it's accepted. We've responded in writing. We'd be here for even longer if I did take up every point. Now, what I'd like to look at and to concentrate on is land value uplift, and we've had some further discussion about this in your evidence in chief. And if we look at your rebuttal, and to 1.2.2 on page 3. And you say that there's a strong body of evidence that shows that quantified transport benefits capture other benefits such as land value uplift, and it's for this reason that the standard tag approach does not include land value uplift as a distinct component of the monetised impacts. And can we, while we've got core document 832 to hand, just go to page 18 and to the table, and the indicative monetised impacts, they are considered at stage 3. So that is part of the value for money assessment to arrive at an indicative BCR, is that right?
Yes, that's correct. And I think, I mean, you questioned Mr. Lewis about this, about my use of the word standard in the standard tag approach. Perhaps that wasn't the best choice of word, but what I was meaning is the I'm not even sure what the right word is. The orthodox or the core analysis, which is of the transport user benefits. So the level 1 and level 2.
Yeah.
So that is what I meant by standard.
What you're saying is that you don't take it into account at level 1 and 2, but you take it into account at level 3, which has a greater deal of uncertainty, but it's still consistent with the value for money framework to get to the indicative benefit cost ratio, isn't it?
It is, but it is normal for a business case not to rely on indicative benefits to get it over the line, if you like. So if your target, DFT target, would be a BCR of 2, you would typically expect the adjusted BCR to be within kind of striking distance of that, and your indicative benefits would then take you over. If your adjusted BCR is at 0.5, as is in this case, it would be highly unorthodox to rely on indicative benefits to take you up to an acceptable BCR.
Well, different schemes have different values, don't they? But let's go back to the value for money framework and go to 4.3.3. It's under the heading Assessing Value for Money.
Page, please.
Page 17, sir. And .3.3 reads, to reflect this in a way which is useful for decision making, the department distinguishes between 3 types of monetised impact: established, evolving and indicative, and these impacts are presented in 3 different BCR metrics. These are initial, adjusted and indicative, and that is the latest advice, isn't it?
It is, but as I was explaining, the initial and adjusted and you've indicated too that the indicative is the one with the greatest uncertainty, and you start your analysis with the initial and then the adjusted to add in the wider economic impacts. And in almost every business case that I've ever looked at, you would expect at the adjusted BCR stage to be, as I say, within striking distance of a target of approximately 2 or higher, and you would then justify the shortfall in terms of perhaps some indicative benefits.
Well, you say that, but this is the latest guidance which says you should go through all 3 stages. And of course this is a change to the previous guidance, and as Mr Whitehouse explained, in the past one look at switching values, but you now, in accordance with the guidance, look at the indicative metric, which is an essential part of the process, isn't it?
Yes, I don't think it's as radical a change as you're perhaps implying. I think it's making the approach more consistent than it was before. I think people had difficulty understanding what the switching value meant. And so this is to try and basically you build up your business case in layers, and there isn't a change of methodology when you get to the indicative. So it is simplifying and making the approach more understandable, but I don't think it radically changes it.
No, it's the third stage of the process.
Yes.
It always has been,
Yes.
but it's now been given a status as level 3.
It has always had that status. It's just it's been clarified what that status is.
And if we go to the table on page 19, typical impacts of a transport proposal, level 1, level 2 and level 3 in the columns, no indication that you stop at level 2, is there? In fact, you'd err if you stopped at level 2, because you should also consider level 3, should you not?
Not necessarily. If you at level 2 you had a BCR in excess of 2, you probably wouldn't spend the time looking at the further indicative benefits, because you've got enough evidence to prove your case. So it would be a choice. I mean, I don't think you need to get to level 3, but you can.
But you can.
Yes.
And some schemes are more dependent on land value uplift than others. I mean, it depends on the purpose of the scheme, doesn't it?
Very much so. But the ones that are typically reliant on land value uplift are parcels of land which are effectively landlocked. So in other words, they're within railway lines and you need to build an expensive new bridge or tunnel or something. This development, this particular scheme, and the developments that it is supporting are not of that nature. Bourne Airfield is not an isolated parcel of land.
But it doesn't have to be isolated. It has to be and just looking at the table there that we've got on page 19, when you're dealing with indicative monetised impacts, one of the elements included in the indicative metric is dependent development, specifically identified, isn't it?
Indeed, yes, absolutely.
And so it doesn't have to be landlocked. What it has to be and you have to form a judgment on, and we're going to have a look at how you do that, dependent development. And if it is dependent development, you take it into account at level 3.
Yes, indeed, yes.
So it's wrong to say that land value uplift is excluded, isn't it? Because land value uplift forms a part of the process if there is dependent development.
Yes, but actually in the context of the point I was making, it wasn't about business cases in general. It was about the specific point that the assessment of the transport benefits of the scheme capture land value uplift, and therefore you shouldn't do both.
No. And in this case, the applicant hasn't done both.
Indeed.
Because the applicant has excluded the
Absolutely.
transport user benefits coming from the dependent development because it's taken it into account as land value uplift.
Entirely right, yes.
Yeah. Now, on dependent development, 2 points I'd like to ask you about. First is, what is dependent development, and in particular does Cambourne West fall into that category? And secondly, if you take out Cambourne West or adjust the values, what are the consequences? And that's the document that went in yesterday, CD 2960. So we'll start on what is dependent development, and you refer to quite properly the relevant tag unit. So let's just have a look at this, find out what the principles are, and then we can see whether they've been applied. So if we go to core document 950, we've got tag unit A2.2, and we need to go in that document to page 19, and we'll find a heading, what is and isn't dependent development. And if we then go to 3.2.2, slightly unhelpfully, this means whether there is dependency is not usually clear cut. So there isn't a simple answer to this question, is there?
Sometimes.
Sometimes, but not usually. There isn't, because they say not usually clear cut.
Yes, I suppose that's what it's saying. But I mean, in most cases, it is absolutely clear. There's no suggestion that there is dependency, but maybe in the cases where it's claimed, it's not always clear cut.
And if you go to the table, there are some illustrative examples. And go to page 20. A large geographically concentrated housing scheme, this is just illustrative, which is accompanied by public investment to improve the capacity of local roads and public transport. And then there is potentially, yes, subject to a dependency test on the right. This is an example where a portion of the new development could come forward without the need to improve transport capacity, but government investment in transport is required to enable the full housing development to go ahead. Without it, the existing transport system would be overwhelmed. So that's an example where the full, and that's a housing development, can't go ahead without the investment in transport. That's given as an example of a potentially dependent development, isn't it?
Yep, subject to a dependency test.
Yes. And subject to the test. And the new bridge, which above, which we're not dealing with, which unlocks industrial land, the port is rather like your landlocked railway line point. And if we then go on to 3.3.2 on page 22 and 23, we get the dependency test which has to be applied. The dependency test demonstrates the extent to which a development is dependent upon a complementary transport investment. A dependency is likely to occur where a development will breach a reasonable level of service in the transport network. And it notes no precise definition of reasonable level of service, such that decisions regarding dependency are ultimately judgment-based. So here we have an ultimately judgment-based decision. Do you agree?
Not entirely, because Appendix A actually sets out, as the next paragraph says, in detail how tests will be undertaken to inform that judgment.
But it's to inform the judgment. Appendix A sets out criteria, but you've got to make a judgment.
At the end of the day, you have to make a judgment, yes.
Yeah. Now, if you take Bourne Airfield, with the condition 13, in place, you cannot have more than 500 units coming forward without the C2C scheme or equivalent.
That is the planning condition, yes.
That's the planning condition, and that planning condition, so long as it remains in place, creates a dependency. Do you agree?
It creates a planning dependency, yes.
Yes. It is a planning dependency, but it's still a dependency, because you cannot, the planning authority have decided to impose that condition.
Yes, but that's not the same as a dependency that this tag unit is talking about, though. In fact, it's almost a difference between a de facto and a de jure difference.
But if that condition is imposed, because otherwise you wouldn't have a reasonable level of service, then it is dependent, isn't it?
Yes, that is the critical test.
Yeah. And if we then look at, just before we move on to dependency on in the tag sense, just take a diversion to your proof, because you raise a point there in the proof 4.3.3. You say that the second point to note is that planning conditions and obligations must pass a test of necessity, necessary to make the development acceptable in planning terms. Now, can we just... And then you say the applicant could apply to vary the condition. Now, by that, do you mean make an application under Section 73 of the Town and Country Planning Act?
Indeed.
So that is an application for planning permission, as the inspectors well know, for the development of land without complying with conditions subject to which a previous planning permission was granted. It's an application for planning permission, isn't it?
Yes.
Yeah. And therefore, the local authority determining such an application has to consider the consequences of changing the condition and substituting it, well, either removing it or substituting it with another.
Yes.
And here, the local authority would have to go back to consider why did they impose the condition.
Yes.
And if they imposed it to maintain a reasonable level of service on the network, they'd have to consider what's the position now and is it justified?
Yes, but interestingly, the reason given for that planning condition is not the highway's impact. It is compliance with policy SS7 in the local plan.
Okay.
So when that was looked at, when that planning condition was set, it was not set with reference to objective evidence that there was going to be an unacceptable impact on the highway or severe impact on the highway network. Otherwise, that would have been cited as the reason.
Well, you'd have to look at the full report and the reasons and the transport assessment to come to that conclusion, wouldn't you?
Indeed, and I have read the officer's report, and the officer's report is clear about something which didn't come through to the decision notice, which is that the applicant would submit a transport assessment at the point where they got to 500 dwellings, and either the transport assessment would demonstrate that more dwellings could be built before the busway scheme was built, or it could decide that no, the busway scheme is required and therefore we cannot continue further. But that choice was clear in the officer's report, but it didn't come through to the decision notice.
But as far as that condition is concerned, it remains in place.
It does, yes.
Has a Section 73 application been made?
It hasn't, and there's no reason why it would, because the applicant hasn't even started building. So,
well, you can make it before you start.
Of course you can, but it's making a judgment as to whether that would be a cost-effective investment of its time and money.
Hasn't been made.
No.
And can we just look at what you're here for CPPF? Can we just look at what their position was at the time that the planning application was considered? So can we just go to core document 040417? as you say, that you've looked at the committee report, and go to page 38 of that document, please. And just look at this, above 280, timing, traffic and transport. So this is a summary of Cambridge past, present and future's concerns. So they refer to the busway, so they contemplate there will be a busway, and then they say this development will significantly increase congestion on the A428 corridor, which is already significantly congested. So the CPPF's position was that there would be an increase in congestion on the A428 corridor. That's their position, isn't it?
It was at that time, and I can't speak for CPPF because I don't think I input into that position, but that was based on the A428 as it was then, which is single carriageway west of Cambourne towards the A1, and that is being upgraded now. So, and also the A14 has been upgraded since then to add an additional lane from the point where the A428 joins it east to the Milton interchange. So actually there is less congestion on that road now than there was at the time that comment was made.
But that was their position.
Yes, but as we know, the world has moved on. It's changed.
And so if condition 13 were to be varied, have CPPF formed a view as to whether they would oppose that variation or not?
You'd have to put that question to Mr.
You don't
Littlewood.
know. And can we then turn from Bourne Airfield to Cambourne West, considering the... well, just before we do, just in case I forget it, in your 4.3.3, and I don't want to take any unfair legal points, but 4.3.3, you say that the planning conditions and obligations must pass a test of necessity, and in relation to planning obligations, you refer to regulation 1222 of the Community Infrastructure Levy regulations, but you refer to section 100 ZA2 of the Town and Country Planning Act 1990. Now that is actually a provision relating to the making of regulations, isn't it? It doesn't directly bite when considering whether to impose conditions.
I may have quoted the wrong
But I don't
source in that case.
not going to make a big point about it, but if you've got core document 508, and in mine it's page 210, 209 and 210. And you're referring to subsection 2.
You're correct, I have quoted the wrong.
Well, I don't
Wrong
think it's
paragraph.
wrong. There isn't a statutory provision of that type relating to conditions. There's a policy in the MPPF.
Yes, I think I got confused and thought that this was the basis for the MPPF
But
guidance. But
I don't take any point of substance on it. But
Okay.
we can cross that out of your evidence.
yes, indeed.
But the important point that I do want to ask you about is that a local authority cannot rely upon a planning obligation as a reason for granting planning permission unless it meets the tests that you have set out, which are in Regulation 1222 of the Community Infrastructure Levy regulations, and one of those is that the planning obligation can't be a reason for granting permission unless it's necessary to make the development acceptable in planning terms. And that
Yes.
we agree on.
Yes.
And so when we go to Cambourne West, can we then just see, because this is you criticise the applicant for taking into account Cambourne West when calculating land value uplift. So can we then go, bearing in mind the points we've just agreed, go to core document 12102, which is the economic case addendum. And we go to page 20.
Yes.
And we can see at 4.4.22 we're dealing with dead weight and dependent development. I'm asking about dependent, but if we go to the second sentence, this is defined as the dead weight housing and represents the number of homes that can be delivered while still maintaining a reasonable level of service on the existing transport network. So the question for you is, do you agree that those who wrote the business case applied the right test from the TAG guidance, which was maintaining a reasonable level of service on the existing transport network?
They've described the test, but they haven't provided any evidence that supports it.
But that is the right test, isn't it?
It is the right test, yes.
And if we then turn to another document in the business case, we need to go to core document 1/2016. And this is Appendix J to the outline business case. And we need to go to page 68.
Did you say 1/2016?
1/2016, page 68, sir, and it should have table 8, development sites and evidence of linkages to C2C project. And in relation to Cambourne West,
Sorry, I haven't found this. Sorry,
page
table.
68, table 8,
Have I got the right? Is it 68 in PDF or the?
it's 68 in the PDF, 63 in the paper, but I think
Right,
most
yes, I've got
people are
it, yes.
working on the PDF.
Yes, I've got it.
And I agree with Mr. Parker that it would be helpful if the numbers were the same, which was one of probably the few bits of useful advice I gave to my clients when we were preparing the proofs. So we see Cambourne West, and we see that in 2017 the council resolved to grant planning permission for a mixed-use development of 2,350 homes at Cambourne West. It notes it's above the 1,200 in the local plan, but the local plan also notes that. And then it says, although there's no Grampian condition that prevented the start of the development and still infrastructure works began, the Section 106 agreement negotiated contributions towards the C2C project. Now, applying the principles we've just agreed, the Section 106 agreement, using the words in the regulation, couldn't have been a reason for granting permission unless it was necessary to make the development acceptable in planning terms. We can agree that, can't we?
As a principle, yes.
Yes. And therefore, if it was not necessary in order to make the development acceptable in planning terms, for the C2C scheme to go ahead, it wouldn't have been justified in seeking contributions to it, would it?
That is correct, yes.
And that illustrates a linkage or dependency between that scheme, the Cambourne West, and the C2C project, because the C2C project, or contributions to it, are necessary to make the scheme acceptable.
Yes, but with the nuance that it is, in this case, is addressing cumulative impact rather than the isolated impact of this development. So the scheme itself is to serve both Bourne Airfield, Cambourne West and the rest of Cambourne. So the benefits accrue to residents of all of those areas. So it is a proportionate contribution to the cumulative impact of all of the development.
But if that development is dependent on the scheme, then there is because it's necessary to make the scheme acceptable, even if it benefits others, it's still a dependent development. Is it not? Because it can't go ahead without it. It's necessary to make the scheme acceptable in planning terms.
Yes, that is strictly true, but we still come back to the difference between the planning dependency and the transport dependency. And the transport dependency is what Tag Unit A2.2 looks at, and that requires evidence from modelling of the transport impacts to determine actual dependency in the sense that's meant in the Tag Unit. So, and therefore dependency for land value uplift assessment.
But if you look at the reality of it, if the scheme can't go ahead without that contribution, the scheme can't go ahead without the infrastructure. And in that sense, you can call it a planning dependency, but it is dependent, isn't it? Because it's in the simplest possible terms, it can't go ahead without the contribution.
That was the assessment at the time of drawing up that section 106, and that was based on a transport assessment that was conducted pre-COVID for that development. So we are looking in 2025 at the transport impacts of this development, and they are likely to be different. So that does not prove dependency now for counting land value uplift, but also it doesn't provide you the threshold at which the development requires the transport infrastructure, and therefore the point at which it becomes dependent. And that's a key point that's in Tag Unit A2.2.
But if you say now, but this, so are you accepting that at the time the business case analysis was conducted, it was right to take this into account because of the planning position? In that case, it was a Section 106 agreement. In Bourne Airfield, it was a condition.
Yes, at that time that was.
It was right.
Yes.
And what evidence, also because there was a transport assessment at the time which identified the number of junctions and so on that would be over capacity, and that was taken into account at the time the Cambourne West decision was made, wasn't it?
It was, but nevertheless there was no planning condition attached that referred to that. No. And normally, if there was evidence supporting the point you're making that the development could not go ahead without that transport infrastructure, then that would actually be conditioned rather than included in an obligation.
Well, that can't be right, can it, Mr. Lee? Because for the local authority, you could decide that the infrastructure is necessary to make the development acceptable in planning terms. How you secure it, you can either do it by planning obligation or by condition. And in the case of Cambourne West, they decided to do it by obligation because it involved the payment of money towards the scheme.
Yes, but it doesn't require the scheme to have been built. So crucially, the whole development could be built out without the busway being built, because there is no condition that prevents it.
No, but the local authority had to make a judgment, and the judgment was that they would secure the money towards the scheme. They couldn't have done that by condition, so they had to do it by obligation, didn't they? You can't secure the payment of money by condition.
No, you can't, but they could have had both the condition, as Bourne Airfield has, and an obligation, as Bourne Airfield does.
But that was a matter of judgment for the planning authority, how they secured.
It was, but it suggests to me that the evidence didn't support having a condition, because you would want a condition if you believed that building all of the dwellings without the transport infrastructure in place was going to overwhelm the highway network. You would want that condition to be in place.
Well, you may want to, but the guidance is that you shouldn't have conditions which are unnecessary, and if a point is covered by the planning obligation, it's not necessary to have the condition, is it? That's what the guidance says.
Well, then, how have we got the condition with Bourne Airfield then?
Well, I'm not asking about Bourne Airfield.
But I know you're not. But
Cambourne West.
But you're saying that the situation that applies with Bourne Airfield.
Well, no, it's a different planning permission. Cambourne West, a decision was taken to secure a payment, and there is also a payment at Bourne Airfield.
Indeed.
And that was a judgment for the local authority, but it makes it no less dependent because they couldn't have secured the planning obligation if it hadn't been necessary, as you've agreed.
Yes, but I think you would also agree that the owner of that site is in no way hindered from building all 3,850 homes that are within the planning permission without the busway being built, and that is something the planning authority permitted.
Well, they permitted it, but they permitted it subject to the applicant entering into a planning obligation which contributed towards the scheme.
Indeed, but it didn't in any way secure the delivery of the scheme.
No, but it's for the planning authority to form a judgment on whether the scheme is likely to be delivered.
Yes.
And that's true in lots of cases where conditions aren't imposed, preventing development going ahead until certain things happen, if a local authority is confident that it will happen.
Yes.
Thank you. Right, let's now go on to the values attributed to the dependent development, and this is the residual land valuation point and the house price growth point. So if we just take up core document 950, which is a tag unit which gives some guidance on this. And if we go to page 28 in that document, PDF page 3421. Now, the preferred method to estimate land value uplift is the residual valuation methodology, see Appendix E. The application of this methodology will require a valuation surveyor, and then contemplates where this is not possible. Land prices can be estimated.
Yep.
But the purpose of the land value uplift calculation is to, as the name suggests, is to look at the uplift in the value of the land.
Yep.
So you're not looking at house prices, you're looking at the residual valuation. So you take into account the value you get, and you take all the costs off, and
Yep.
you find out what the residual value is. And as you will be well aware, that involves a significant number of judgments. And for residual value, you then may ask yourself, does whatever we come up with in a different context, you're asking, does it exceed the benchmark? But here we're just looking at residual valuations.
Yes.
And if you adjust one element, as demonstrated by Mr. Whitehouse rerunning your figures, if you adjust one element such as house prices, there are other adjustments that have to be made because that affects gross development value, and you have a profit element which is expressed as a percentage of sometimes cost, sometimes value, but usually value. And so if the gross development value comes down, the costs come down because some costs are a percentage of the value.
Indeed, yes.
And if one looks at that preferred methodology and then look at what the applicant did in this case, if we look at core document 12102, which is, I think, if I got it right, the outline business case addendum economic case, and we go to page 22, we will see there a heading towards the bottom, gross development value. And gross development value is the estimated total revenue a developer could obtain from the land in the context of housing. It's calculated by house prices times the number of dwellings. And what the applicant did was to take values from a valuation surveyor's report, and that's the Aspinall-Verdi report. And that's the report you referred to, which was prepared for the local plan process. And Aspinall-Verdi referred to at 4.4.31, and then if we take up core document 2960, we've got in those voluminous appendices the Aspinall-Verdi report.
Are we going into that?
We are. And we're going to go to page 58 in the PDF. I'm not going to attempt the internal number of pages. And we can see, if you go to table 5.1, which is on page 57 probably, beginning of it, page 58, Cambourne is said to be in a lower value area. And then values are adopted for different areas, and for the lower value zone, values are adopted for 2-bed, 3-bed and 4-bed houses. So that's the approach that was taken. And can we also note at page 149, looking at towards the bottom of 2.7, there's a reference there to there being likely to be a new build premium for developments and they happen to be referring there to North Stowe and another development in Cambourne. But even though there's likely to be a new build premium for these developments, average prices are still significantly lower than central Cambridge. So that's the approach taken by the applicant. So what I'd like to do is now compare it with your approach. And on page 24 of your proof, you've got a paragraph 4.4.8.6.1. But it's the paragraph at the bottom of the page if one can't manage all the numbers. So the average house price in Cambourne West and Bourne Airfield asserted in the economic case assessment is 506,051 based on an estimated land value of 4,761. Well, the first question there is that what one should be looking at is land values which are dependent on house prices, but it's the land value which you should be looking at when considering land value uplift, isn't it?
It is, yes.
Yeah. And the 4761, we've looked at the derivation of that, so don't go back to that. But what you then did was to seek to, in your words, validate this by looking at actual house sales. And you have looked there at Rightmove. And you say that they're reasonable proxies for estimating the notional average house price at this development. And then you refer to the land registry as well. So, first of all, if you've taken an average price, is it based on the type of homes likely to be provided on the development site, or is it just an average which includes all type of homes?
No, it was just an average across all types.
Yeah. So it would include small...
Sorry, it is an average across all types.
So if the development is likely to be 2, 3 and 4 bed houses, for example, your analysis takes into account 1 bed flats, and to be fair, at the other end of the scale, 5, 6, whatever bedroom houses as well.
It does, and it's based on the mix of housing that's currently there in Cambourne for the Rightmove and Highfields Qualicut, and for South Cambridgeshire, then the whole mix in the district.
And it's no allowance for new home premium in your analysis?
No, but as I was only doing a kind of sense check, and as we've already established, Cambourne is at the lower end of the value spectrum within South Cambridgeshire, so therefore if we took an average across South Cambridgeshire, you would expect Cambourne to be lower than that. So if we take the average, then we're boosting it, and that partially corrects perhaps for the new homes premium.
Well, it demonstrates that it's quite a what might be called a rough and ready analysis, because it doesn't look at the specific homes that are likely to be provided, it doesn't look at new home premium, and it takes an average over a wider area.
You're entirely right, but I draw your attention to my paragraph 4.4.8.12 on page 27 of my proof, where I say, to be clear, although I am claiming that the inputs used in the Langley analysis in the ECA are very likely to be incorrect, I am not claiming that the inputs stated are definitely correct. Right. So I'm not trying to do what Aspinall Verdi did, or that the applicant did. I'm simply trying to sense check it using available data.
And what you say there also is your assertion is that the indicative BCR is highly sensitive to the inputs, which you say are based on challengeable assumptions. And that's the point you're trying to make.
It is indeed, yes.
If you change the, as in any exercise of this type, you change the inputs, you change the answer.
Indeed.
And of course, another factor which isn't taken into account is the point you make in your rebuttal at 1.2.2 in the rebuttal on page 3, which is that house prices are affected by relationship with transport. The closer you are to, not always, but often, if you're close to good public transport, railway, bus route, tramway, there's a price premium.
Yes, usually yes.
And that isn't taken into account by taking an average.
It isn't, but there are parts of South Cambridgeshire that have access to good transport, that have railway stations. So, we're averaging those in the mix.
Yeah, you're averaging them in the mix, but here you're looking at a scheme which is designed to improve public transport, and that the houses are going to, we're looking at dependency. So they're going to be close to the public transport scheme.
Well, some are, but actually the design of Bourne Airfield puts the busway at the northern edge of it, so people who move into the south of it are actually not that conveniently.
But they're on a development which is served by public transport.
They are, but not all of the homes will accrue a premium because of proximity to the busway.
Okay. So next we're going to look at the sensitivity test tables. And so we may do that in the just under 10 minutes we've got till 1 o'clock, unless you'd rather stop there and we start again, because I don't think we will get through that by 1. And after that there isn't a great deal to go after that. So I can carry on, but we might end up at 10 or 1:15, or stop now and start again, whichever you'd prefer.
Yeah, I think actually there's a convenient spot. We'll break for lunch now, and then you can continue afterwards. So I'll make it 12:52. Oh, hang on, hold up. Yeah, sorry, Mr. Clegg was reminding me of actually what I did say to start with is obviously when Mr. Lee's evidence is finished, we'll be coming on to Professor Hurst. So I was going to ask Mr. Parker, do you think you'll need a longer lunch? I know we're not going straight into Professor Hurst's evidence to consider it, or the new information that's come in, or that you're providing, and Mr. Cameron.
Mr. Henderson.
Oh, Mr. Henderson, sorry.
Yeah, well, I got there about half an hour ago, so I've skimmed read it as we've been going along, sorry. But let me have lunch, and I'll let you know when we come back immediately from lunch, if that's all right. So I think it's better to come back from lunch, deal with Mr. Lee, and then if I need half an hour, then we'll take half an hour then, if that's the exception.
Well, in that case, yes, we'll resume at 10 to 2, and we'll take a view then as to whether we need to take some extra time after Mr. Lee's finished. Thank you very much.